In the realm of evidence, presumptions play a vital role in guiding judicial reasoning. Among these presumptions, conclusive presumptions stands out for its absolute nature.
Conclusive presumption is an inference which the law makes so peremptory that it will not allow it to be overturned by a contrary proof, however strong. Datalift versus Belgravia, with GR number 144268, on August 30, 2006, it is an artificially compelling force which requires the trier of facts to find such facts as conclusive presumed, and which renders evidence to the contrary inadmissible. Conclusive presumptions can be classified into: number 1, those that are not based on estoppel; number 2, those that are based on estoppel.
Examples of conclusive presumptions not based on estoppel: A. Children under 9 are conclusively presumed to lack discernment and are exempt from criminal liability and contributory negligence. Jarco Marketing Corporation versus CA. In People versus GAA, in statutory rape, the law conclusively presumes a child under 12 cannot give valid consent, making proof of force or consent irrelevant. Letter C. Those who have open, continuous, exclusive, and notorious possession of public agricultural land since June 12, 1945 or earlier are conclusively presumed to have met the requirements for land ownership under CA 141 and PD 1526. Letter D. If a negotiable instrument is with a holder in due course, valid prior delivery is conclusively presumed. If not in possession of the signatory, valid delivery is only presumed rebuttably. Negotiable Instruments Law, Section 16. Letter E. When a person dies due to a deliberate act, intent to kill is conclusively presumed. This is under the case of Bitol versus People. Letter F. Plaintiffs in a class suit versus the Marcos estate in the U.S. are conclusively presumed to be human rights violations victims under RA 10368, Section 17.
However, in this discussion, we will focus on conclusive presumption under Section 2, Rule 131 of the Rules of Court. Section 2, Conclusive Presumption. The following are instances of conclusive presumptions. First, whenever a party has, by his own declaration, act, or omission, intentionally and deliberately led another to believe a particular thing to be true, and they act upon such belief, he cannot, in any litigations arising out of such declaration, act or omissions, be permitted to falsify it. Letter B, a tenant is not permitted to deny the title of his landlord at the time of the commencement of the relation of landlord and the tenant between them.
Conclusive presumptions under the rules of court are based on the doctrine of estoppel. Under this doctrine, the person making the representation cannot claim benefit from the wrong he himself committed. For example, and by the way of correlation, persons who assumes to be a corporation without legal authority to act as such shall be considered a corporation by estoppel and shall be liable as general partners. The ostensible corporation is not allowed to use its lack of corporate personality as a defense. It is stopped from doing so.
Rule 131, Section 2A, provides that wherever a party has, by his or her own declaration, act or omission, intentionally and deliberately led another to believe a particular thing true, and to act upon such belief, he or she cannot, in any litigations arising out of such declaration, acts or omission, be permitted to falsify it. Related to this, conclusive presumption is Article 1431 governing estoppel in general, which states that
Article 1431. Through estoppel, an admission or representation is rendered conclusive upon the person making it and cannot be denied or disproved as against the person relying thereon.
In 1993, spouses Lopez secured a $3 million real estate loan from Planters Bank to build a 4-story dormitory. Due to worsening political and economic conditions, costs increased, prompting them to obtain an additional $1.2 million loan funds. However, the bank refused to release the final $700,000, citing the couple's breach of contract for constructing a 6-story building instead of the approved 4 stories. As a result, the spouses sued the bank in 1984 for rescission and damages, claiming they were unable to complete the project due to the withheld funds.
For its defense, the bank argued that spouses Lopez had no cause of action. It pointed out that its refusal to release the loan was the result of spouses Lopez violation of the loan agreement in undertaking the construction of a 6-story building instead of a mere 4-story building as stated in the contract.
All rise, please. By order of this honorable court, session is now declared open. Let us pause for a moment of prayer.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless us, inspire us, that we may be saved, the purpose of your will, enlighten our minds, strengthen our spirit, and fill our hearts with the word of love, wisdom and understanding, so that we can be effective channels of truth, justice, and peace in our proceedings today. Take us in the path of righteousness for the fulfillment of your glory. Amen. Please be seated. Call case number 1.
Case number 1. Planters Development Bank versus spouses Ernesto and Florentina Lopez. Appearances, please.
Good morning, Your Honor. Attorney Season for Petitioner Planters Bank.
Good morning, Your Honor. Attorney Macala for the respondent, heirs of spouses Lopez.
Let's proceed to the proofs of the matter. The key issue here is whether Planters Bank is justified on refusing to release the balance of loan for the reason stated.
Yes, Your Honor. We argue that the bank should be still proclaiming breach as they had knowledge of the construction divisions and failed to object. Under Rule 131, there's a conclusive presumption that once a relationship is established and accepted, the party cannot later deny it.
Respectfully, Your Honor, that presumption applies only if the contractual obligation were fulfilled. The spouses Lopez deviate from the approved building plan and fail to submit the required reports. The bank withheld the remaining loan balance for just cause. Estoppel cannot apply when the term of the agreement were not honored.
But Your Honor, the bank knows my client has substantially complied with the bank requirements. In fact, the bank had conducted multiple ocular inspections on site. The bank's silence on the alleged breach on the contract terms by my client is an implied agreement. Shouldn't their inaction matter? Inaction or silence may under some circumstances amount to misrepresentation. To raise an equitable estoppel, when the silence is of such a character and under such circumstances that it would become a fraud on the other party, to permit the party who has kept silent to deny what his silence has induced the other to believe and act on, it will operate as an estoppel. This doctrine rests on the principle that if one maintains silence when unconscious he ought to speak, equity will debar him from speaking when unconscious he ought to remain silent.
Silence in the face of knowledge and continued conduct stops Planters Bank from not opposing the deviation. Under Section 2B, Rule 131, their inaction amounted to equitable estoppel. Their argument was nothing more than a legal afterthought. However, after careful deliberation, a court rules in favor of the petitioner. Planters Bank did incur delay. It does not rise to the level of fundamental breach. Rescission is not justified under these circumstances. The court affirms the validity of the foreclosure. Case closed.
In this case, the Supreme Court upheld the CA's finding that the spouses Lopez consistently submitted accomplishment reports supported by testimonies of their engineer and the bank officer. Under Section 2, Rule 131 of the Rules of Court, the bank's in silence and inaction despite knowledge of the breach amount to equitable estoppel. However, the court disagreed with CA's conclusion on rescission, ruling that the bank's refusal to release the remaining loan amount was only a slight breach, not enough to justify the rescission of the contract.
Rule 131, Section 2B provides that the tenant is not permitted to deny the title of his or her landlord at the time of commencement of the relation of the landlord and the tenant between them. Related to the second kind of conclusive presumption is Article 1436 on comodatum and lease, which provides that
Article 1436 of the Civil Code provides that a lessee or a bailee is stooped from asserting title to the thing lessed or received as against the lessor or bailor.
Next case.
Case number 2. Datalift Movers Incorporated and Jaime B. Aquino versus Belgravia Realty and Development Corporation and Sampaguita Brokerage Incorporated. Appearances, please.
Good morning, Your Honor. Attorney Season appearing for the plaintiff, Belgravia Realty and Sampaguita Brokerage.
Good morning, Your Honor. Attorney Macala, pleading for independence, Datalift Movers, and Mr. Jaime Aquino.
Counsel for the plaintiff, you may now present your case.
Your Honor, this is a straightforward case of ejectment. Our client, Belgravia and Sampaguita, are rightful sublessor of the warehouse in Pandacan, Manila. In 1990, Belgravia and Datalift executed the written lease agreement for 40,000 monthly. When the contract expires in 1991, Datalift continued possession without renewal but with tolerance and getting an implied lease. From 1994, because of increase in PNR rental, Belgravia adjusted Datalift rental to 130,000 pesos. Defendant refused to pay the adjusted rate and eventually ceased payment entirely. Demand letters were sent, no compliance, hence we filed this complaint.
With due respect, Your Honor, my client challenged the very basis of this ejectment case. Belgravia is not the owner nor the lessee of this land. The title belongs to PNR. Sampaguita's lease with PNR expired in 1990. Without proof of renewal, neither Sampaguita nor Belgravia has authority to lease or demand rentals. Moreover, the increase to 130,000 was arbitrary and without agreement. My client merely stayed on under mutual understanding. That doesn't equate to valid consent to such an unjust increase. The increase is both oppressive and without legal basis.
Counsel for the plaintiff, do you have proof that Sampaguita's lease with PNR was renewed?
Yes, Your Honor. While there is no formal written renewal, PNR did not eject Sampaguita or Belgravia even after June 1990. This continued occupancy amounts to a tacit renewal.
You acknowledge the lease and paid rent for years. Under the rules of court, particularly Section 2131, a tenant cannot question the title of the landlord. Your clients admitted the lease and benefited from it. How can they now deny Belgravia's right?
We acknowledge the lease existed, Your Honor, but only under a valued agreement. Once the contract expired and a new and exorbitant lease was imposed unilaterally, the lessor's right becomes questionable. Your Honor, we will present our witness in the person of Mr. Aquino, representative of Belgravia.
Swear the witness.
Please stand up, Mr. Witness, and please raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name,
Mr. Aquino,
age,
58 years of age,
civil status,
married,
address.
Pandacan, Metro Manila.
Attorney, your witness is now ready.
Mr. Aquino, did Belgravia ever presented you with a new lease agreement when they raised the rent to 130,000 pesos?
No, Your Honor. They just sent a notice saying that rent was raised. I found it excessive, so we stopped paying and awaited the negotiation. But you remained in the warehouse. Yes, because we believe the previous terms applied. We were willing to pay a fair rate.
Upon evaluation of the pleadings, evidence, and applicable laws, a decision is hereby rendered. The decision consists of 12 pages. Counsel, do you want to read all the 12 pages decision?
No, Your Honor, only the dispositive portion.
Please read the dispositive portion of page 12.
Based on the facts and admissions, this court affirms that an implied lease existed, and that failure to pay rent is sufficient ground for ejectment. However, the court finds the rental high to 130,000 pesos unreasonable. Thus, the court found that original rent was set at 80,000 pesos monthly from November 1994 onward. Wherefore, judgment is hereby rendered ordering the defendants to vacate the warehouse at number 883 Santibanez Street, Pandacan, Manila. 2. To pay Belgravia 80,000 per month from November 1994 until vacating. 3. The 30,000 pesos attorney's fees award is deleted. 4. No cost. So ordered.
Session is adjourned.
In this case, GR number 144268, the Supreme Court ruled that a tenant, Datalift, cannot challenge the landlord's Belgravia's title or right of possession as long as a lease exists between them. By entering into the lease, paying rent, and enjoying possession, Datalift is conclusively presumed to recognize Belgravia's better right, regardless of actual ownership.
Exemption. The conclusive presumption set forth in Section 2B of Rule 131 does not apply in the following cases. First exemption, where the landlord-tenant relationship has been clearly sufficiently established or where the very existence of the relationship is the very issue of the case.
In Consumido versus Ross, GR number 166875, the Supreme Court held that the conclusive presumption under Rule 131, Section 2, Paragraph B does not apply because the existence of a landlord-tenant relationship was in dispute. Since the petitioner denied any lease agreement and the respondents were not registered owners of the property, estoppel could not be invoked.
Second exemption, if there was a change in the nature of the title of the landlord during the subsistence of the issue.
In Bori versus CAGR number L57204 and Ermitanio versus Paglas GR number 174436, the Supreme Court clarified that conclusive presumption against tenants preventing them from questioning the landlord's title only applies if the landlord's title remains unchanged from the start of the lease. If the landlord's title has expired, been transferred, or defeated by a superior claim during the lease, the tenant is not stooped from claiming it.
In conclusion, conclusive presumptions under Section 2, Rule 131 of the Rules of Court are legal fictions established by law that admit no contradictions, regardless of evidence to the contrary. These presumptions serve to uphold legal stability and efficiency by removing any room for doubt once the conditions for their applications are met. By mandating acceptance of certain facts as true, they reinforce the authority of law and prevent endless litigation over matters the law has already resolved. Ultimately, conclusive presumptions are powerful tools of judicial policy designed to protect public interests and streamline the administration of justice.
Thanks for watching!
Subscribe.